Hi everyone, and welcome to Avali Law PLLC's immigration channel. I'm Avali, founder of Avali Law PLLC and an immigration attorney. A lot of people ask me, if someone is undocumented, can they get a green card just by marrying a US citizen? It sounds simple, but the truth is, it depends. The process isn't the same for everyone. It all comes down to how you entered the US and your immigration history. Let's talk about it. Before we get into whether marriage can fix immigration status, let's first talk about what it really means to be in unlawful status. There are two main types. 1. Unlawful entry, entry without inspection. This means someone came into the U.S. without going through an immigration checkpoint at a legal port of entry. For example, crossing the border without a visa. If you entered this way, you don't have an official record of admission, which makes applying for a green card much harder. You may be accumulating unlawful presence from the very first day you entered the U.S. unlawfully. 2. Unlawful presence, visa overstay. This happens when someone entered the U.S. legally, on a tourist visa, student visa, or work visa, but stayed past the expiration date. So, while both of these situations create problems, the legal options for fixing your status through marriage are very different. There's a common belief that marrying a U.S. citizen automatically leads to a green card. That's not true. It depends on your situation. If someone entered the U.S. legally but overstayed, can they still apply for a green card without leaving? The answer depends on who is sponsoring you. Under INA Section 201, B, immediate relatives of U.S. citizens, including spouses, unmarried children under 21, and parents of U.S. citizens who are at least 21, are exempt from certain adjustment bars under INA 245, C2, and INA 245, C8. This means they may still qualify for adjustment of status inside the U.S., even if they have unlawful presence. If you are the immediate relatives of U.S. citizens, they do not need to maintain continuous lawful status to qualify for adjustment of status. This means that even if they overstayed their visa or worked without authorization, they can still apply for a green card inside the U.S. without having to leave for consular processing. Let me tell you a story about Lisa. She came to the U.S. on a B2 tourist visa. She planned to stay for 6 months, but ended up staying for years without renewing her status. Then, she met John, a U.S. citizen, and they got married. Lisa was worried because she had overstayed her visa. She thought she might have to leave the country and apply for a green card from her home country. But because she had entered legally and was married to a U.S. citizen, she was still eligible to apply for a green card under INA 245A. She didn't have to go through consular processing, which would have required her to leave the country and risk triggering a 3-year or 10-year re-entry bar. If you entered the U.S. without inspection, that is unlawful entry, you cannot adjust your status from within the U.S. because under INA 245A, to qualify for adjustment of status, you must have been inspected and admitted or inspected and paroled into the country. Since those who entered unlawfully don't have a legal entry record, they don't meet this requirement. So, what's the solution? You would need to leave the U.S. and apply for a green card through consular processing at a U.S. embassy in your home country. The problem? You may be accumulating unlawful presence from the very first day you entered the U.S. unlawfully. Leaving could trigger a 3-year or 10-year bar from returning under INA 212A9BI, depending on how long you were unlawfully present. If you overstayed for more than 180 days, but less than a year, leaving could result in a 3-year bar. If you overstayed for 1 year or more, leaving could trigger a 10-year bar from returning. This is why so many people who entered unlawfully feel stuck. They can't apply for a green card while staying in the U.S., but if they leave, they risk not being able to return for years. Now, are there exceptions? Yes. While most people who entered unlawfully must leave to get a green card, there are some exceptions. One example is Parole in Place, a special program under INA 212 D5 for military families. It allows certain undocumented spouses, parents, and children of U.S. military members to receive a legal entry record, making it possible to adjust status without leaving the U.S. And that's just one example. There are other exceptions too, which we'll cover soon, so stay tuned. Okay, that it is. So, does marriage to a U.S. citizen fix your immigration status? It depends. If you entered legally but overstayed your visa, marriage may allow you to apply for a green card without leaving the U.S. But if you entered illegally, marriage alone won't solve your immigration issues. In most cases, you'd have to leave the U.S. to apply for a green card, which could trigger a 3-year or 10-year re-entry ban. Every case is different, and one wrong step could make things worse. Before making any decisions, talk to an immigration attorney to understand your options and avoid costly mistakes. If you have specific questions or need personalized advice, feel free to reach out to our firm. We offer 30 minutes of free consultation. Visit our website to schedule an appointment or submit your case for evaluation. Email us at info@avalola.com. Thank you for watching, and we'll see you in the next video.